going live. Okay, so we are live and it's recorded. Yes. So Guna, thank you very much. And this is not just going to be, this is a series. You are one lecturer. You take your lectures the way you want to. That's one structure. People who want to follow you, they follow your lectures, that series. So whatever way you want to. Although I did say that we have to start with the basics, because I've definitely, we're trying to bring into the fold those people who otherwise might not have ever a opportunity to go for a lecture on mediation. So just inspiring them, getting it in. So good, a little bit of an introduction, and this is your lecture room, and obviously I'm out of it. So please.
Thank you, Vikram. Right. Hello, everyone. Very good evening. Thank you for joining me even at this late hour, because I know many of you are busy. My name is Gunavathi. You can call me Guna, as everyone knows me. Mediator Guna, and invited by Mediator Vikram for this series of lectures in Mediator Vikram's Mediation Academy. Thank you very much for the invitation, Vikram. As usual, it's always a pleasure to present for you. And I've been a mediator for more than 30 years, actually. And when I started learning about mediation, I became very passionate about it as it went along, so much so that I decided to share my knowledge with, students, friends, lawyers, anyone who comes across my path, because I think it's such a beautiful process. It's a peaceful process, which I think all of us should learn, not even only if you want to become a mediator, but to use it in our everyday lives. So that is why I found mediation very passionate, and I believe that it works. And that is why I'm here today presenting this lecture to you. I am by profession a lawyer, an advocate and solicitor, as we are known in Malaysia. I've been an advocate and solicitor for more than 35 years, but mediation is where my heart is. And that is why I like to participate in this lecture series or anything else which has to do with mediation. And I think many of my colleagues here as well, like David, I know is also very passionate about mediation. So I'm very pleased to see David here today. So let me start off this mediation. I know I wanted to focus on the role of lawyers in mediation, but Vikram told me, Guna, please start with the basics. I've actually watched the other previous lectures from the other lecturers. They're all very interesting, but they're kind of deep and nothing basic as such. So I think Vikram asked me to start off with something basic so that, people who have not been exposed to mediation will be able to benefit from this. So what I'm going to do today is going to talk about some basic mediation principles, what it is. And because I'm an advocate and solicitor and I'm a lawyer by profession, I want to show and I want to pass this message along to lawyers that mediation works. It's not second best to litigation. So I want to stress on that, because I am very passionate about this, that sometimes lawyers are the stumbling blocks to mediation. And I will share with you why. So on that note, can I just share my screen? Right. Can you all see my screen, Vikram?
Yep.
Right. And what I'm going to do is I'm going to put it on slideshow. Right. So today I'm going to, as I said, I'm going to talk about very basic mediation stuff. So for senior mediators, this may not be very interesting, but I'll try and make it as pleasant as possible for everyone. And let me start off. This is my agenda for today. I'm going to start off with the real basic of all basics. What is mediation? And moving on to the general principles of mediation, the different styles of mediation. I'm only going to focus on 2 styles very briefly, and then move on to some of the benefits of mediation, the role and functions of the mediator, and lastly, the role of lawyers, which I wanted to initially talk about today. So what is mediation? as we all know, it's a process where parties who are in a dispute meet mutually, and they've come to the mediation table mutually, voluntarily, seeking the assistance of a neutral and impartial facilitator who's going to help them in their negotiation of their dispute or their differences. So it is a process in which disputing parties involve an impartial third party who is called a mediator, who will facilitate the parties' attempts to arrive at a settlement. And this settlement must be a consensual settlement agreement towards resolving a dispute. So this is very unlike an arbitration or litigation. Litigation, we all know that the court and the judge hands down a judgment at the end of the day. And in arbitration, the arbitrator will hand down an award which is binding. So both in arbitration and in litigation, arbitration is very akin to litigation, because at the end of the day, a third party is going to make a decision for you, which is totally unlike mediation, where the mediator does not make a decision for you. So it is basically the facilitation of a negotiated agreement by a neutral third party who has no decision-making power. So this diagram actually shows what takes place in mediation. The disputants are here. The mediator's aim is to get both disputants to share what their interests are, why they are at mediation. These are all mediation or negotiation terminologies: interests, options, and alternatives. Okay, so basically interests of the parties would be why they are there at mediation. What is it that they want? What are their needs? What are their desires? What are their goals? So that's what parties are going to come to mediation and share with the mediator and the other party. What is it that they really want? And along that process, hopefully the mediator will be able to encourage the parties to come up with options for settlement. Options basically mean possible ways of resolving a dispute. So parties may lay 4 or 5 options on the table. They talk about the options, they discuss the options, they evaluate the options, and at the end of the day, come up with a resolution by weighing what their alternatives are, which generally would be whether they wish to settle on the table at mediation, or maybe go to court, or go to the press, or maybe even go to arbitration, or any other form of dispute resolution. So that is an alternative. So parties weigh all this and then reach a mutual agreement with the assistance of a mediator. Now, some of the basic principles of mediation are as follows. One is assistance by a third party. Of course, there's always a third party who is impartial or neutral, who is the mediator. And there is facilitation by the mediator. So the mediator is crucial to this process. It is also a self-determination, parties are able to determine for themselves how they want to resolve the disputes. So parties are fully empowered to make their own decision. I think this is one of the main attractions of mediation. But again, as I was just telling my students last week when we spoke about this, that we really don't know whether this is really the truth in the Asian culture. And I think we've spoken about this, and David, I think, is full of smiles because he knows that David has written a paper on this. So the suitability, I think we should have a discussion on this. And I think they are having this discussion in the IMAW ADR Settlement Week, whether this is actually true and whether it is a suitable model for mediators in Asia, especially, where sometimes I feel it's true, because I don't think in Asia, people are actually, I don't know, I speak from on behalf of my colleagues here in Malaysia, but at times I feel that, you know, when parties come for mediation, they want the mediator to make a decision for them. They are very uncomfortable if somebody doesn't make a decision for them. Not all parties, but most parties, like, they come to mediation and say, oh, so you're not going to make a decision for me. I said, no, I'm not going to make a decision for you, because they're expecting someone to make a decision for them because they're so used to people making decisions for them. So this is something which we may need to inculcate in our, you know, I know, to our clients as lawyers, that, hey, look, I'm not going to make a decision for you. The mediator is not going to make a decision for you, but you're going to make your own decision. And it's going to be a mutual decision between yourself and the other party. So the authority for making that decision comes from the parties themselves. So this is something which I think in our culture, we are not really exposed to this making decisions for ourselves, especially when it's taken to the court all the time. But now I think, of course, with the growth of mediation and with people like Vikram and me and David and Giovanni and all our colleagues who are so passionate about mediation, I think if we were to spread the word around and tell people that you have this ability or empowerment to make a decision for yourself in your own dispute, so why not do that? Yeah. So these are some of the general principles of mediation. Now, of course, there are many models of mediation, as you can see from this diagram: facilitative, evaluative, directive, transformative. All this is too technical. Let me just explain this in very simple terms. And I'm just going to focus on two different types of mediation model, which is the evaluative mediation and the facilitative mediation model. So what is evaluative mediation? Right. So when you look at evaluative mediation, if you look at this diagram, it actually explains everything, where the mediator is in the middle. You have party A and party B. But because it's called, the terminology itself, evaluative mediation, indicates or signifies that the mediator is going to make an evaluation. Because he's going to make an evaluation, he must have subject matter expertise in respect of the matter which he's going to be called upon to evaluate. So that would obviously mean, let's say it's a construction dispute, the evaluative mediator would have to be someone who has subject matter expertise in construction law, or maybe not law, but he's familiar with the terminologies, the contract documents, etc. For example, an architect, a quantity surveyor, or even an engineer. And there could be co-mediation as well between two where two parties are appointed to co-mediate a construction dispute, because documents could be voluminous and it is quite technical in nature. So you could have one mediator who is an engineer or a quantity surveyor, and the other person a lawyer. So because subject matter expertise is required. So what the mediator is going to do is, the evaluative mediator is, they are characterized as more prone to actively trying to narrow the topics for discussion. They're going to assess the opinion of the law, the merits and demerits, what seems fair and working, in order to narrow the settlement range between the parties. So this is an attempt actually to cajole the parties to agree. So how he's going to do that is going to weigh the strengths and weaknesses and then give a non-binding opinion by challenging the predictions of the outcome. So at the end of the day, if required, the evaluative mediator will give a non-binding opinion, but this opinion is not binding on the parties. So it's entirely up to them if they want to comply with that opinion or agree or defer, that's entirely up to them. So this is what happens at evaluative mediation, and it is popular and it is useful for certain types of disputes. For instance, where liability is not really an issue, but we're just talking about damages. For example, in road accident cases in Malaysia, it forms the bulk of the cases in our legal system. So for this kind of disputes, I think it's very suitable because liability can be determined and narrowed down by the parties, and they just talk about damages. And I have actually conducted workshops for judges, and the judges have given me this feedback that they have conducted evaluative mediation in their courts, especially in accident matters, and they have found it so useful because they can easily settle about 10 matters before them in a day. So that's very good standards for them, for their key index performance, right? So for them, it is good. So this is what evaluative mediation is. Of course, there are advantages and disadvantages to this. Advantages is, of course, it can be completed very quickly, and it saves a lot of time. Disadvantages is because, of course, there's a huge debate for mediators out there. I mean, there is a huge debate whether you should have evaluative mediation in the first place, and then there's another debate as to whether there is strictly a facilitative mediation model, and the debate as to whether there is evaluation in all types of mediation, whatever way you want to term it, whether it's facilitative or transformative, whether an element of evaluation exists in all these different types of mediation. So that's a story for another day. So moving on, facilitative mediation. Now, in facilitative mediation, I think in the 1960s and 70s, there was only one type of mediation when mediation first started off, and this was the type of mediation which was being taught. And I mean, I learned facilitative mediation. I think many of you would have also learned or were trained in facilitative mediation, how to become a facilitative mediator. Very rarely do you get courses teaching you to be an evaluative mediator. It's normally the facilitative mediation model which is being taught. So it is basically a private, voluntary, and flexible process. And you have the neutral, the mediator who's the neutral and impartial third party there. And he's going to use different skills and techniques to assist the parties to reach a mutually satisfactory outcome. So if you look at the elements of it, I've broken this down here. It's voluntary and informal. Voluntary because parties have come to mediation voluntarily. Informal because the process is very informal. It's very unlike a courtroom or even an arbitration. We don't refer to the rules of court, or we don't refer to the rules of evidence. As I always say, remove the word irrelevancy when you're talking about mediation, because everything is relevant. Nothing is irrelevant. Like in a court of law, we object that this is not admissible. That piece of evidence is inadmissible because it's irrelevant, etc. But there's nothing like that in mediation. You tell your story from your heart and you speak freely, right? So this is done in the presence of the neutral and impartial facilitator, who is not going to make a decision for the parties, but only to assist parties in opening up the channels of communication which has broken down between the parties. So he's going to encourage them to talk to one another, negotiate openly in front of the mediator. And the other hallmark of mediation is, of course, confidentiality. Now, everything which is said at mediation remains in the mediation room, it's strictly confidential. And if mediation doesn't, if parties don't settle at mediation for whatever reason, then whatever happens at mediation stays in the mediation room. And if they were to go to trial, they will not be able to share what happened at mediation. The proposals for settlement put forward at mediation will not be able to be used at the next set of proceedings, which is the court proceedings, or maybe even arbitration. Okay, and of course you can have lawyers, which I will be sharing with you all later about lawyers being present, and parties can also go to mediation without lawyers, right? But they can have their lawyers if they so wish. And the most important thing is coming up with your own decision at the end of the day. Now, moving on to the benefits of mediation. Now, mediation is, of course, quick because you can have a quick resolution. You can do it within a day, depending on the nature of the dispute, of course. And it saves a lot of time and costs because, of course, if you have lawyers on board, lawyers may come to mediation, but of course, their legal fees may not be as high as if they were to go to court. So that's what I'm going to talk about later. Why lawyers may sometimes view this as not suitable for them because they don't even want to talk about mediation or encourage clients to go for mediation because of this. And in fact, tomorrow there's going to be a launch by our Bar Council. This is something which is very commendable. Our lawyers are going to have a pledge, a mediation pledge, to say that, so lawyers, firms who sign this pledge are going to pledge that they will opt for mediation first instead of litigation. So I really do not know what the statistics are going to be in respect of the number of firms who will voluntarily come and sign this pledge, but it is something very encouraging and promising for mediation, and I hope it works. And hopefully lawyers who sign this pledge will keep to their pledge and promote mediation, right? So let's, I will keep you all posted, Vikram, about the success of our mediation pledge in this country. So hopefully it works. Now, coming back to this, of course, I spoke about confidentiality just now, and it being an informal process. And the other thing is preservation of relationships. Of course, at the end of the day, if parties settle, they can preserve relationships. They can shake hands at the end of the day and say, thank you very much for settling. Let's do business together again. Yeah. So this is something which is one very advantageous benefit, yeah, which I think many businesses or commercial businesses should take into account instead of rushing to the courts and look into resolving their disputes in a more amicable manner like mediation. And of course, earlier I did speak about party control, and that parties get to decide for themselves how they want to decide their own outcome. And of course, there is an opportunity to come up with creative solutions, creative ways of resolving a dispute. And let me just share a quick story about how attractive mediation is and why I feel that mediation is so workable. There was this probate matter where two parties were, this gentleman, the deceased person, he left a will, but he only left, he was married officially to one person, and the other person was a common law wife. And what happened was he left everything to one wife's family. So the other wife's family was like left out of the will, the common law wife. And what happened was they contested the will. The second wife's family contested the will, and they decided to go for mediation, fortunately. And these were Chinese people they were Chinese people, and in the 60s and 70s in Malaysia, it was quite common for people to have two wives until they came up with the Law Reform Act, where it says that you cannot have two wives or three wives, except for the Muslims in our country. You can have 4 wives, right? But like for the Chinese and the Indians and the other races, we can't. So what happened here was they came for mediation. In fact, my friend did this mediation. I did not. And I'm sharing this story with his consent. And somehow during mediation, what actually helped parties to decide was when they found out what was it that the second wife really wanted. The second wife only wanted an acknowledgement from the first wife's family that she was part of the family and that she was actually this man's wife. So on the tombstone in the cemetery, the second wife's name was omitted altogether. Only the first wife's name was on the tombstone. And during mediation, after this came out, I think the settlement, the creative solution which actually settled this dispute was the first wife's family agreed to change the tombstone to have the second wife's name and the children's names on the tombstone, engraved on the tombstone. So that resolved the dispute. So it was such a fantastic way of resolving the dispute, because this is, how we can resolve disputes at mediation. Imagine if this case had gone to court. This kind of a creative solution would not have been possible at all. No way. So that is the beauty of mediation, coming up with creative solutions to resolve disputes. So that is why you can achieve a win-win solution. For different disputes as well, not necessarily just family disputes. It can be even commercial disputes, working together, going into a new joint venture or an apology. So things like this make a difference in mediation, which you can never obtain in a court of law. Okay, so that wraps up the benefits of mediation. Now, very quickly, this is how mediation works. This has been put very simply. And basically, you have 2 sessions, the joint session, which is the top part of the mediation model. Then you have the private sessions, and you resume with the joint session again. Of course, you can have numerous caucus sessions or private sessions in any mediation. There's no hard and fast rule that can only have one private session. It can be any number of private sessions. So it generally begins with the pre-mediation meeting, where the mediator will meet with the parties to set out the roadmap for the mediation and lay down certain rules, sign the agreement to mediate, and then move on to the mediation date itself. So at the mediation, on the mediation day, the mediator will then start off the session by giving his statement, getting the parties to speak and not their lawyers, identifying the issues, talking about the issues in detail, and if there's an impasse or a deadlock, then of course they move to a private session.
No.
Vikram, there seems to be some disruption.
Done. She was Kalyani was thing. Done.
Okay, thank you. And Subsequently, of course, parties will weigh the options and offers which have been put forward on the table, and hopefully they resolve at the end of the day. But generally, this is how it works. But I don't want to go into too much detail about how this works. Okay. Right. Now, what is the role of the mediator? What is he going to do? So the mediator basically is going to leave the decision making totally and strictly with the parties. And the mediator does not decide what is fair or what is right or what is wrong. He does not assess blame. He's not going to render an opinion on the merits. So we're talking about a facilitative mediation model, because the evaluative, of course, is expected to give a non-binding opinion. Okay. The mediator's role here is actually as a catalyst. So he's going to act as a catalyst between opposing interests, attempting to bring them together by defining issues, trying to eliminate all obstacles and in communication, and then he moderates them, he guides them into avoiding confrontation between them, and at the end of the day, structuring some sort of a resolution. So he has quite a lot of work to do, and it's not easy being a mediator. Judges whom I have trained have actually told me, they said, oh my God, it's difficult to be a mediator. We didn't expect this. It's so much easier to be a judge. That's the feedback I get from judges. When I train judges, they say it's easier to be a judge than to be a mediator. And I totally agree, because as a judge, you're not trying to get two parties in disputes to talk to one another. I think that's one of the hardest things to do in mediation, is trying to get parties to talk to one another and managing the process. So let's talk about what the mediator does. So the mediator is going to perform a number of functions. It's an art. Mediation is an art, as I would say. They are going to practice their art during mediation. So they manage the mediation process and assist them to move forward. Now, the primary function of the mediator is to manage the mediation process. As the manager of the process, the mediator encourages the parties to talk broadly about the issues that brought them to the mediation table. And this would include talking about any information or feelings which they want to express. Now, this is, of course, not available in court, right? We can't express our feelings and emotions in court, but in mediation, you are expected to do that. You're encouraged to do that. And one of the main differences between mediation and the other ADR processes, as I said, is everything is relevant, right? I spoke about that earlier. So they need to speak freely about the dispute and express their feelings and emotions so that they are understood and so that they are acknowledged. And sometimes that sense of acknowledgement, like the example I gave you earlier about the tombstone, is something which really can either make or break the mediation, right? So all this is done by the mediator, managing the process, facilitating the conversation between the parties. Now, this is extremely difficult because parties may not want to speak to one another. They will be speaking to one another through the mediator, which is not what the mediator wants. The mediator would then encourage them to speak to one another instead of through the mediator, because they are all present there. And if they don't converse with one another, how are they going to negotiate a settlement for themselves, right? So this is one of the most important tasks of getting the parties to converse with one another. And he needs to help them to move from their rigid positions, not be so set in their ways, by trying to encourage them to express their feelings, their needs, their interests, their underlying interests. Why is it that they're clinging on to to a position which they want or a demand which they are making. So it is only when you go and work into this deeper level that meaningful progress can be made in the mediation, which would end up in a win-win situation at the end of the day. And the other is problem solving. Now, this is also a very huge role of the mediator, a huge, huge role, because the mediator needs to go through the issues with the parties, explore as many options as possible, and try to bridge the gap between the parties so that they need to change their mindset into this problem-solving mode, or problem-solving mindset. So if you come into mediation without having that mindset, it is very difficult to resolve problems, yeah? Because the parties will be so set in their ways. And next is to create a safe environment. Now, creating a safe environment is very important in mediation because parties must feel safe coming to mediation. And this does not mean, of course, that you cannot allow them to express their feelings and emotions. I mean, emotions can run very high during mediation, especially like in family disputes. It is not easy because I'm not being gender biased, but sometimes I've done quite a number of family mediations, and I've seen how the men bully the women. I mean, by staring at them across the table and giving them dagger looks. So all this, the mediator needs to be aware of all these things, creating that safe environment, because there is going to be acrimony. There is going to be heated exchanges, but it's how the mediator manages these expressions of conflict between the parties, because you do not want to cause any further damage to what has already been done. And of course, this is not an easy task. And the mediator has to, of course, be attuned to all this, practice some of his skills, be empathetic towards the parties, balance the needs to encourage emotional expressions, at the same time keeping the whole environment safe. So this is another important role of the mediator. Next would be to balance power. Now, I think this is also very difficult task to do. Now, the mediator has to be very alert. He needs to look out for signs. He needs to look out whether there is a power imbalance. And it can be apparent by way of non-communication signals which are being sent out by the parties, because we all know in mediation, communication is so important. And so is non-verbal communication. Non-verbal communication, sending out dagger looks, as I said earlier, can also be very, very damaging. Or if one party decides to keep silent and not speak at all, then that can also be very damaging. In fact, I'd just like to share a short story about my experience in this. When I attended a mediation training workshop in Canada. And I was very fortunate because I had a very experienced mediation trainer, and they, of course, followed the Harvard principal negotiation techniques, and they taught us all the techniques. And I was able to observe a real life mediation done by my trainer. And I was his mentee at that time. And it was very strange because this set of parties came into the mediation room. It was an employer-employee dispute. And the employer was a big company, and the employee was an immigrant in Canada. So he came with his lawyer, who was also an immigrant, just the both of them. And the other party, the other side, was a big corporation. They came with 4 lawyers and their representatives. They came with their briefcases, their suits, and they all looked so smart. Whereas the other side, the immigrant was not wearing a suit. He was just wearing a shirt, and he looked so meek and frightened. So immediately you can sense the power imbalance in the room as a mediator, and you could tell that, you know, the immigrant, the employee, he was very uncomfortable. And after a while, we had to go into a shuttle mediation because the employee was very quiet and refused to speak much. So thereafter, the entire mediation process took place in a shuttle mediation. So shuttle mediation, for the advantage of people who do not know what a shuttle mediation is, let me just quickly tell you what it is. It is where the mediator puts both parties in two separate rooms, and the mediator shuttles from one room to the other room, trying to speak to one party and then go and speak to the other party, and then hopefully come to a resolution. So parties are separated throughout the mediation. This is also common, could be for disputes like sexual harassment. Yeah? For these kind of disputes, you can have shuttle mediation because the victim may not want to face the perpetrator. Yeah. So coming back to my story, so very quickly the matter was settled. So we were a bit taken aback. How come this matter settled so quickly? And it was because there was a huge power imbalance. And I was telling my trainer, my mentor, I said, oh my God, this is not fair. This is not fair at all. He's agreeing to a decision which is really not in his favor, but he accepted the terms. So coming back to the question of whether I'm digressing now because this is another very interesting topic about fairness versus neutrality, whether the mediator needs to step in like in this situation, because he feels in his mind that this decision which the employee is reaching is not a very fair decision for him. But the question is, should the mediator step in, or should he maintain his neutrality and keep quiet? Because the person is there, he's voluntarily agreeing to the settlement proposed. So why should the mediator step in and say, this is not a fair resolution? That's not the place of the mediator. Anyway, that's a discussion for another day, fairness versus neutrality. So coming back to this balancing of power. So this is what the mediator needs to do, balance power. And sometimes factors like gender, ethnicity, age, sexual orientations, education, occupation, financial issues, all this could lead to a power imbalance in mediation. So this is where the mediator needs to be wary of. And of course, lastly is the mediators. One of the mediator's roles is to structure the resolution of the parties. So he guides the parties through the steps of the mediation process. Of course, there's a structure, which I showed you all earlier. Encourage effective negotiation behavior and help the parties explore interests and needs which they seek to meet in resolving their dispute, rather than be fixed on their demands and positions. So trying to move parties, make them transition from being so entrenched in their positions and looking at their interests to resolve the dispute. So how he does that is by assisting the parties to generate a range of possible options, including creative solutions, which I discussed earlier. And very importantly as well, the mediator must recognize a deadlock. If there's an impasse, he needs to know what may happen if they fail to reach a resolution. So that is another thing which the mediator needs to do. And the other thing is to evaluate the options, help parties to evaluate options by, of course, creating doubts, reality testing, all these skills which we learn during our mediation training has to come into play to help parties evaluate their options to resolve the dispute amicably by themselves. So that is the other role of the mediator. Now, moving on to the last topic, which is representation at mediation. Now, when disputants consider whether they should go for mediation, they may opt to be represented by lawyers at mediation. They may proceed without lawyers. They may proceed with a representative who is not necessarily a lawyer, and after mediation, get lawyers to prepare the settlement agreement. Now, these are the options which the disputants have. So it's entirely up to them whether to pick a lawyer or not to pick a lawyer to assist them. Of course, for cost reasons, sometimes people come to mediation without lawyers. And speaking about the role of representatives first. Now, when we talk about representatives, I think when you're talking about representing a disputant at mediation, I look at what that means is that the person accompanying the disputant to mediation is actually a peacemaker. I think, Vikram, this is something very close to your heart, peacemaking. Making peace and not war requires a different mindset altogether. Now, this is the ability to problem solve through discussions and to seek a solution acceptable to all parties. Sometimes people call it deal making as well. How to make deals, right? Now, when you talk about, now there's this, there's so many workshops going around everywhere on mediation advocacy. Now, is mediation advocacy a misnomer? I'll talk about that in a while. And why I'm saying this is, I might as well talk about it now because we're talking about mediation advocacy and the number of workshops which are going on and training sessions being offered. When you talk about mediation advocacy and ask why, whether it's a misnomer, is because it is not advocacy in the sense of the real word of advocacy, because we are not going to court and pleading someone's case before the judge or arbitrator or speaking for the other in respect of a proposition. We are not doing that at all. So sometimes being a senior lawyer, right? Many senior lawyers actually don't see the point. And I've trained so many people. I've trained close to 800 to 1,000 people, and half of them are lawyers. And I've had senior lawyers in my workshops, and I see them struggling during the role plays because they're so set in their ways. It's difficult for them to make that paradigm mindset shift, to move away from the traditional way of thinking as an advocate. So for them, so imagine if this person who's not a trained mediator, who is an advocate for many years, representing a client during mediation, and his mindset. So the failure of traditional advocates or senior advocates, principally because they're all court-going lawyers, they may not be able to let go of their forensic approach to overcome an obstacle to effectively represent their clients at mediation. That's my view, okay? Because I've seen this at these workshops, people struggling to grasp the ability to problem solve, because the mindset is not a problem solving mindset. It is more combative, like what we are taught in law school, to be combative. As I always say, in law school, we only have moot competitions. We don't have mediation competitions. Only recently ADR is taught as a subject in Malaysia. But why are students not taught to be problem solvers, to be negotiators? This is where it starts. My view is it has to start from there. So if you become too entrenched in your traditional way of being combative, and if you were to represent if that sort of a lawyer were to represent a client at mediation, I don't think the mediation is going to be successful. And I actually saw that last week when I did a mediation myself. And that's why I can speak with such conviction that, everyone should undergo a mediation training workshop, whether you want to be a mediator or not, because it helps you assist your clients or represent your clients effectively at mediation. And the mediation advocate must remember that he's not there to convey his client's case to the mediator and the other side, but he has the role as the client's advisor. So he's the client's advisor to protect his client's interests as he sees them and make sure that it works. But sometimes these two duties can actually conflict. And so he needs to know where to draw that line. And that is why there needs to be a change of attitude. There needs to be a change of attitude. So that attitude which I'm talking about is mediation is not second best to litigation. So that is why I'm quite happy that the Malaysian Bar Council has come up with this pledge to mediate first, right? Because mediation is not second best. Mediation is peacemaking. So when you make peace, you have your day in court and it's not war. Having your day in mediation is making peace, whereas a day in court is making war. Okay, that's, and I just like to quote Lord Falconer, who said in this Chartered Institute of Arbitrators annual mediation conference in 2012, he said this. He said, mediation is not so much a matter of training, but more of a cast of mind. So the mindset is so important. So the only purpose, in my view, of being a representative at mediation is to be a peacemaker. Every client is different, and so is every dispute. And you can make peace in many different ways, if only they are trained how to do it and to have the right mindset to do it. And as I said, because earlier, I mean, the other thing which the mediation lawyer or advocate, as they say, must realize, he is there resolving disputes. They are not trying a case before a judge or an arbitrator. So he needs to be an honest deal maker or an honest broker in trying to arrange a settlement deal between the parties who are in dispute, to put it very simply. And so this is what I spoke about earlier, making the decision to have that mindset. And what the lawyer needs to do is to assess the suitability of the case and the nature of the dispute so that you pick the right mediator for the dispute. Because sometimes subject matter expertise is important. So if it's a construction dispute, I think it is good to have subject matter expertise. Even in family law, you need to have additional training because you need to empathize a lot during family disputes. So that is also an important factor, picking the right mediator. Timing, when do you mediate? Before the proceedings have commenced, or after close of pleadings, or before trial, after trial? All this has to be assessed by the lawyer who is going to be the representative. So once they have decided who the mediator is, this is pre-mediation, encourage the parties to talk about the dispute, and the nature of the mediation process must be explained to the parties, what they can expect, and then pick the right mediator. Okay. So we spoke about mediation advocacy just now. Next is the selection of the mediator. I think I touched on that earlier, looking at the nature of the dispute and the appropriate experience which the mediator has in that particular area of dispute. and whether he has the appropriate training. Reviewing the fee schedule of the mediator, checking on where the mediation is going to be held, and the conflict of interest check. Now, this is important, whether the mediator is known to any of the parties in dispute, because you do not want to breach your rules of conduct. I think in most mediation organizations, there's a rule of conduct, and you want to do this conflict check first. And of course, the mediators would have prepared an agreement to mediate, to review that agreement to mediate with the clients, and to go through with them and explain it to them that it's confidential and that it's privileged, that they will not be able to use the information there once if mediation is unsuccessful. And very importantly, I think lawyers need to guide their clients to prepare the pre-mediation papers. Now, this is very important because the mediators would expect some sort of a brief description of the case about what has happened. I just want to share with you the mediation which I did last week. It was in respect of a construction dispute. And the parties had gone for arbitration. And during arbitration, there was a need to pick an expert to come up with some evaluation of some cost estimates in respect of rectification of defects. And the parties picked an expert, and the expert came up with his expert opinion report, but there was a dispute with regards to the fee which was payable to the expert. So parties came for mediation before me. That means the expert and the client who picked this person to give the expert report. So the client was a big developer. So the developer came to mediation. Both sides were represented by lawyers, and the developer's lawyer was trained in mediation because he was my student. So I had trained him. He knew what to prepare, and his summary, when they came for the pre-mediation meeting, I told them, you have to come up with a summary of your dispute and give me relevant documents. Of course, this is a construction dispute. We're talking about a construction dispute. So he came up with a very thin bundle of documents. Whereas the opposing counsel was a very young lawyer, and he wasn't very familiar with the process. I'm sure he didn't know what mediation was all about. But the party himself who came for mediation, who was representing the company, he was the man behind the scenes, and he had prepared the expert report. He was a mediator himself, and an arbitrator, and an adjudicator. So he declared openly at the pre-mediation meeting, when we had the pre-mediation meeting on Zoom, and he said, oh, I'm Miss Guna, can I also mention that I'm a mediator and an adjudicator and arbitrator? I said, oh, very good, Mr. So-and-so. And then he tells me, I'm looking forward to this mediation, and I really hope that, it will be successful. I said, well, I was very pleased to hear that. But on the day of the mediation, as I walked into the mediation room, I was shocked. I saw the projector was turned on, the screen was down, and there was there was going to be the use of a projector. And I said, why would I want to use a projector during mediation? And I mean, this is just on fees, it's just a mediation which I don't think I need to use a projector. So I asked the parties, who asked for this projector to be set up? And the lawyer says, oh, my client wanted it. I said, what is it for? Oh, we have prepared a presentation for you as the mediator. I said, I don't think I would require that. I said, I think we should bring down the projector, turn it off, because I would like to use the board. It's eating up the board space. And I like to use the whiteboard when I'm mediating. And I said, it's taken up more than half of my whiteboard. I have no more space to write. So I said, no, this projector has to go up. So I told them to turn it off. So when it was his turn to present the case, of course, I encourage the clients to speak for themselves. As we all know, that's what we do as mediators. We want to hear from the clients. And he says, I've actually prepared this presentation. I would like to give you my PowerPoint slides. And I said, that is not necessary at all. I said, this is mediation. Why don't you tell me in your own words what happened so that you can share this with the other party as well. And we can all discuss what you have in a very informal way. And I was so shocked that they gave me a 400-page bundle of documents for mediation. And I'm like, and I just kept it aside. I said, I'm not going to make any reference to any of the documents for now, because I don't think it's necessary. And he was trying to take the documents, refer. So this is what I mean. When you are a lawyer representing a client at mediation, preparing the pre-mediation papers is extremely important, because you want to give a summary of the case, not a submission. It's not a submission to the mediator. So what the lawyer had done was to prepare a brief as though he was going to court and present a submission to a judge. But I refuse to read it, because I think there's no need to read it. Everybody should share what they want. I say, speak from your heart. So identify the key factual and legal as well as non-legal issues. You can provide some documents to the mediator, like the pleadings or the principal agreement, but you don't need to give the mediator a 400-page mediation bundle, right? So what happened, let me just finish the story about the mediation. Of course, the mediation, I could not settle the dispute between the parties, because the mediator come arbitrator come adjudicator who was present at that mediation, who was speaking for himself, was so positional. He was so fixed in his ways, because he felt that he needed to present his case, like what he was doing in a court of law. And during my caucus session with him, I did a reality test with him. And he said, oh, I know what you're trying to do. You're trying to do your reality testing with me. And I can tell you now, my underlying interest is my reputation. So he was just being a smart cookie. So it was very difficult, because he knew what I was doing, yet he was not very helpful, and he was very fixed in his ways. But finally, he did come up with some options for settlement. But that was not good enough for the other party. And the other party's offer was also not good enough for him. So he said, I would rather take my chances in court. He told me that in caucus. And I said, what is your best alternative? Going to court, of course. And I said, your worst alternative? I don't think the worst thing, nothing will happen to me. He says, I'll go to court and I'll get my money. I said, then why did you come for mediation today? No, I think he came on a fishing expedition as well. In my mind, that's the feeling I got. So it is very important for the lawyer to ensure that you prepare your client effectively. And this can be done at the pre-mediation stage by giving a proper statement of the issues and positions. Contested issues and uncontested. Make sure the client knows what his interests are, his underlying interests, of course. And very importantly, the strength and weakness of the case. In the case which I couldn't settle, this disputant just refused to see the weakness of his case, although there was a huge weakness and his reputation was at stake. Yet he decided not to do that. But as lawyers preparing clients for mediation, we have to do that. We have to identify the strength and weaknesses, and the strength of the weaknesses as well. And what about the cost element, the risk element? He told me during caucus, I rather pay my lawyer the money to go to court than to, because the gap was so small. It was only 55,000 Malaysian ringgit, which was a very small gap compared to what he was asking. And yet I couldn't settle it because he said, I rather pay that 55,000 ringgit to my lawyer. He told me that. And well, you have to assess for yourself what your risk. And I said, what about the time taken and your reputation? Oh, well, I'll take my chances in court. So it's very important to have that mindset change and talk about the range of possible options for resolution and the strategies to achieve that final outcome at the end of the day. And it's also very important to ensure that the person who will attend the mediation has the authority to settle the dispute. Now, this is also very important, and why my mediation failed that day was also because the developer sent someone who did not have full authority, in spite of me reminding them at the pre-mediation meeting that the person should have full authority to settle. And they assured me that the person attending mediation had full authority to settle. And on the day of the mediation, when he was asked to consider the option, he said, I'm sorry, I have to check with my boss. So I was taken aback and I said, you have to check with your boss. I thought we made this very clear from the outset that you had full authority to settle, and you came with a board resolution from your company, from your board of directors, saying that you have full authority to settle. Nevertheless, he did not. And I told him, can I adjourn this for a short while and you go and make this call to your boss and check with him? No, I don't want to do that. I said, well, that might be helpful. You can take 10 minutes, 15 minutes. I can even give you half an hour. And he declined my request. So that was another reason why the mediation failed. So for lawyers who are preparing their clients, this is extremely important. So the role of the lawyer during the mediation process is that of a problem solver, as what I said earlier. He needs to be collaborative with the other side. So you work with your clients, not for your clients, because the lawyer's role at mediation is as an advisor for their clients. And the goal is, of course, to get a beneficial solution for both parties. I think the danger in not advising your clients properly prior to coming to the mediation table is another reason why mediation fails if lawyers are there. And I think it's very important for lawyers to advise their clients the strengths of the other party's case as well. Because if you only look at it from one side, the party may actually be misled into thinking that he has a fantastic case, and why should I go to mediation and settle? I'll take my chances in court. So he has to assist the clients to give proper practical and legal advice on the process and on the issues, on the offers which have been made. And lastly, of course, to draft the terms and conditions of settlement as agreed. Of course, the lawyer has to maintain confidentiality as well, and make sure that all this information and documents are kept confidential, draft the offers, counter offers, and very importantly, act in good faith to attempt to achieve settlement. And I think one of the other important things which the mediator needs to do, which the lawyer needs to do during the mediation process is, as I said, you need to look at it as being a peacemaker. Peace at mediation is obtained by not overwhelming the other side. You don't want to do that. And it is actually achieved by finding common ground on which a settlement can be constructed that meets the reasonable expectations and needs of both sides. So to achieve this, the representatives or the lawyers must work out the value of the settlement, not the value of the cost, but the value of the settlement as a peacemaker. He needs to strategize the settlement, explain to the client that the mediator is not a judge. The mediator is there to assist them to resolve their communications and negotiations which have broken down. So participation from the client is extremely important. And now, of course, we all know that this is the role, these are some of the roles of the lawyer: assisting, participation, avoiding arguing with or attacking your adversary, and addressing yourself to the decision maker and to the other side. Now, all this looks hunky-dory on paper, but in reality, the question one has to ask all lawyers out there who are listening is, do we really do that as lawyers representing our clients during mediation? Or are we actually the stumbling block to our clients achieving a settlement at the end of the day? Like in Malaysia, under our suluh system, which is mediation in the Sharia courts, lawyers are excluded during mediation. I do not know the reason behind it or the rationale for doing that, but I feel that maybe they do not want lawyers to come and scuttle the deal or whatever. But even in our court annexed mediation in Malaysia, what the judges have been doing is they allow the lawyers to attend the mediation process, but they're only brought in. It's a very strange way of doing it. The lawyers come in, speak to the mediator about what the problems are and what the brief facts of the case are, and then the lawyers are sent out, and then the parties come into the mediation room without the lawyers, and the lawyers are kept standing outside for hours sometimes. And if they can't settle, they come back, the mediation is called off. But of course, if it's settled, then they enter into a consent judgment. But most of the time, the lawyers are not there. This is the way the court mediators handle mediation. But private mediators like me and my colleagues, we don't do that. We have the lawyers present during the mediation process. So coming back to that question, whether the lawyers there are really going to I mean, even a lawyer who has been trained to represent a client in mediation, in reality, is he going to do all these things? Is he going to check and tick these boxes and say that this is what I'm going to do? Or is he going to remain that adversarial person which he is when he comes into mediation? So they have to make sure that they take off that adversarial hat and wear the collaborative hat when they represent their clients in mediation. So don't be impatient to begin your bargaining as a lawyer. Don't add fuel to the dispute, and do not encourage your client to focus only on the strength. Think about the weaknesses as well, and don't mislead the mediator about your client's position. So coming back to this and to conclude, what I can say is, I read this somewhere just earlier today, where they posed this question, whether in reality, if lawyers are representing their clients during mediation, in practice, representatives assumes one or more of the three overlapping roles. One is a hired gun, or a bodyguard, or a coach. So I think you need to take your pick. As a peacemaker, what are you going to pick? The hired gun role, the bodyguard role, or the coach's role, right? So these are the wise words of a wise man, Abraham Lincoln, and to all those out there who think that, to all lawyers especially, because I think the question is whether lawyers feel that mediation is done at the expense of their livelihood or their rice bowl, because they feel that if you go for mediation, you cannot make as much money as when you go to court, right? So they are very concerned. And I think that's why mediation has not really taken off in a big way in Malaysia. I speak for the situation in Malaysia. I do not know what is the position in India or in Israel, David. I don't know. But here, I think that's why the Bar Council has come up with this pledge, because they're finding that there are very few cases being referred to mediation at the mediation center under the auspices of the Bar Council, because many lawyers, I feel, they think that it's a threat, and they don't even encourage or inform their clients about ADR. They don't even talk about mediation at all. They just keep quiet about it. So because we do not have anything in our rules of court to sanction lawyers who do not promote ADR, maybe it's timely that they amend the rules to say that you must encourage parties to go for mediation first. So to end my lecture today, I'd just like to quote Abraham Lincoln when he said that as peacemakers, the lawyer has a superior opportunity of being a good man. There will be business enough. So with that, thank you very much, Vikram, for this invitation. And if anybody has any questions, I would be happy to answer these questions.
Thank you, Guna. Always a pleasure listening to you.
Thank you,
And
Vikram.
I'm very happy that I'm back in class. I love this. So that's good. But let me also point out, you said in terms of me being a peacemaker, there is this workshop that I did today on the draft mediation bill that we have just come out with. And you would not see that this is a peacemaker. I'm very passionate about the fact that the whole concept of mediators coming out and getting opportunities and how the law affects that. I have my radical views on that, on the judiciary and the court system. So that was not, it would not seem very peacemaking in that sense.
But you are a peacemaker yourself, Vikram.
But yeah, but that aspect of it, I'm a little, I still say it's peacemaking, but I have very strong views on that. But I think that, of course, we'll get into that. But I mean, this is going to be a series. So Guna, you have to have things to go in our future lectures. Or you have to take, yes.
David can be next.
David has to be there. Yes, we have to ask David also. So, but what I was wanting to show was this Abraham Lincoln quote that you had. I just want to go to my website for a minute. Just also to let people know, I'm also trying to now tell people about my website. So go to mediatorvikram.com. You have my contact details, everything. Talk about, I put the map also that I do exist. Some people might think that this guy doesn't exist physically. So I'm there, and that's my location right now. So, okay, support, schedule of activities, please have a look. Everything is there. You have to just go show more and you can see what's happening. Okay, so that's just one part. I just want to go to Abraham Lincoln's quote for you, what you did. I want to show them the full quote because it's up there. So I would like to show that. This is what it really says, the full quote.
Yes.
So discourage litigation, persuade your neighbors to compromise whenever you can, point out to them how the nominal winner is often a real loser, fees, expenses, and waste of time. As a peacemaker, the lawyer has a superior opportunity of being a good man. There will still be business enough. So that's really important what you pointed out to them. But one more quote that I want to point out to them is what Gandhiji said. So I'll just come to that. Of course, okay, symposium, all the sessions are there, 97 speakers up to now. So please have a look at that, and YouTube channel, whatever is put up, lecture series is all available there. So but this quote is, I find, very important for lawyers to read, and they should. I followed it, so they can also follow this. As a lawyer, I totally relate to his experience. That my joy was boundless. I had learned the true practice of law. I had learned to find out the better side of human nature and enter men's hearts. I realized that the true function of a lawyer was to unite parties riven asunder. The lesson was so indelibly burnt into me that a large part of my time during the 20 years of my practice as a lawyer was occupied in bringing about private compromises of hundreds of cases. I lost nothing thereby, not even money, certainly not my soul. That is really important. So wanted to put that across, because this is something which actually, I mean, is it something that we should not generally put all the lawyers in that position? I'm sure there are good people there, but this is what has become a general thing all over the world. So definitely we need that kind of a spiritual thing also for lawyers. I think, Guna, you need to work on that also. Give them some spiritual aspect also.
Sure.
So, so your students, I don't have any question. I put out in the chat that if they wanted to put any question, they all said very good presentation. Only one person said very good presentation. So no questions have come in. So anyone still has a question or something, she's available. Put your virtual hand up. I'll try and get you in. So that is one part. Other thing that I've also started doing, Guna, is that I've started putting out all the things that I do in a month. I've also started showing that presentation. So because I've been saying that the LinkedIn and Facebook algorithm doesn't show everyone's posts for sure. So people miss out on a lot of stuff that I do because they don't see it. So best is to subscribe to the YouTube channel. Then in that case, you get to know what videos are put across. But I'll just take 1 second to take a little more than that. Just go through whatever. This is the symposium. Of course, Guna was there. You have to see her session also, really educational. So this is now called the Woodstock of mediation. I love that terminology. Then this is the series that I started called Mediator Experiences. Memorable experiences that mediators, not in mediation specifically, it could be in general in the mediation world. So this Weinstein Jams International Fellow aspect was something which was important to us, and something which was really maybe changed people's lives in that sense. Yes, maybe, but it was something important to them. So I've done this thing, a lot of episodes of this, which is still continuing. So there's Adi, of course, from Romania, Taipei, Singapore. All these are done. These are on the YouTube channel available. So their experiences, how they made friends and friends for life. It all actually started with Migle. Migle, in her In Conversation with the Beautiful Mind, spoke about the fellowship. That's when I got to know about the fellowship. Then Katerina, Ivana, all this is done. This is coming up. There are two more people already, scheduled. I think three more people. This is a discussion on the mediation law. This is a workshop that I said I did today. And my whole view on how we have such a good law in India on mediation, but people have been saying there's no law in India on mediation. So I was talking about that. This is the lecture series. This is the inspiration behind the lecture series. That other show that I do, Evolution of a Mediator, this is what Ken said. And I felt that if a person can be inspired so much, it can change someone's lives. Let's put it out. Let's go beyond the mediation world, which I've been complaining about, that no one shares it outside the mediation world. Just put it down on WhatsApp. If Guna's lecture, just send it out. As many people that you can send it out to. We don't know who's going to get inspired and whom we can get into the fold. We have to get these people into the fold. So Michael Lang's, of course, wonderful person. His lecture has happened. This is In Conversation, Beautiful Mind. And then this lecture, this all happened. Okay, Bernie Meyer, Mayer is, of course, should be looked at. He's a very senior mediator. His journey of life. This has just happened. Then we have, this is a very interesting thing about what reflective practice that Michael does. So he's getting his reflective practice people at the session, and they'll go to take us how they go about it. So it should be a very nice session. Then you can get a discount on the book because he's known for reflective practice. This, of course, very interesting person, interesting thoughts on mediation, also art and mediation, and all. Her session on the symposium is also very interesting. You'll have a look at that. Rafael is the one which designed that poster from Mexico. So he's coming up. Then Andrea is also part of Michael's reflective practice group. She comes in for our meetings also. So nice person there. Then on last day of the month, birthdays of mediators in that month. So I've done my bit to tell people, if they see, they don't see. Now I can't do more than this. So no questions. And I don't know whether there is something else that anyone wants to say. So at this point, maybe we can end this session. What do you say? Anything last encouraging thing? Don't you tell people? Because what you said about this mindset thing, at one end I keep saying mediator mindset. On the other end, I'm saying mediation mindset. Both the mindset have to work together.
Correct.
So we have to develop the mediation mindset and circulate that also.
So I hope my students listening in and
Kalyani has something.
anyone who's going to listen, who will be listening it on your YouTube channel will have that mindset change and have that mediation mindset change as well.
Okay, but I'm getting, look, I can get Kalyani in, but although the instruction to everyone is that please put your questions in the chat, because I mean, we don't know
She's put her
what,
hands up.
she's put her hands up. She's put her hand. But I don't, I'll get her in right now, but I don't get her in because, look, let's see the question, what it is. We don't have to take up everything that comes our way. But please, Kalyani, you can unmute yourself and ask what you have to ask.
Yeah. Hello. Thank you, Guna, for the refresher course. I attended Guna's session, several sessions of mediation, and thank you very much because I have been doing mediation for financial institutions for more than 10 years. And I can say that 70%, more than 70% is all resolved on the table through mediation.
Excellent. Very good
We are the peacemakers between the banks and their customers. So end of the day, they will shake hands when they leave the room. Most of the time, if they don't agree, then as in Malaysia Financial Mediation Bureau OFS, we make recommendations and decisions, which is binding on the banks, financial institutions. Now, Guna also mentioned that parties do not come with an authority to resolve. Banks do not send. They are supposed to send senior personnel who have the authority to resolve, but they do not. They send their downlines and then they'll come and say that we need 1 or 2 weeks to resolve. So we give them the time. We give them the time, the space to go and decide. Let them know what is the decision. And if the bank makes an offer, we get back to the customer, to the complainant, to say this is the bank's offer. We try to mediate off the table. We try to resolve it. The other thing is, in the Financial Mediation Bureau OFS, we do not allow lawyers. Lawyers are excluded simply because we want it to be a level playing field. Customers are just laymen, complainants are laymen, customers of the bank, and they feel intimidated when they find a lawyer sitting across representing the bank. So for that reason, at OFS, we do not allow lawyers in.
But I'm telling you, Kalyani, my view on this is that if the mediator has to reach that point and people have to respect, or they can trust mediators to that extent that they can be a citizen, a person sitting in the village and the prime minister of the country on the table, but the mediator should be able to take care of that power imbalance. That is when then mediators will be at the point where that respect should be there, and if that is where we have to get. So that I just feel that sometimes people think that they should cut this out so that they can take care. But I still feel that should not be the way.
We will meet the lawyers separately. If the lawyers insist, we will have a separate meeting with the lawyer and their client.
This is what is also happening in the courts. So I don't know whether it's correct or incorrect way of doing things. But when you mentioned about people being on the level playing field, I tend to disagree with that. I mean, just hear me out for a short while, because the bank is an institution. The consumer is a layman. Yes. So of course there is a power imbalance there as well.
Yes, that's right.
So they are really not on level playing field if you look at it strictly in the sense of the word.
Yes, that is where, as a mediator, when they come for the meeting, we make it say, look, we are impartial. You don't have to worry. It's all within the 4 walls. Okay, you can state whatever you want to state. So we make it very comfortable for the customer to open up.
Okay,
I agree with you. The bank is already an institution. It's very intimidating, right? So we try to make it subtle. But if the lawyer's presence is there, then they think that the bank has got a stronger case.
Kalyani, I think maybe the purpose of this lecture series is for people who might not be so, they might not have access to information on mediation and other things, but it is not really on the practice that, because these individuals and everyone will have different practices, it might just confuse people. At this stage, I don't want them to get so much into these aspects, because they will, from their own experiences, take it forward. That's the way I am looking at this series, because there is a lot of material out there on the practice of mediation by different people. There is so much out there. I mean, people can get access to that who once get into the fold of mediation. There is so much. I have so much on my YouTube channel. There are playlists of all kinds there. Hundreds and hundreds of hours of material is lying there. So I think people can pick it up. I'm trying not to confuse people, because the mediation world has so much there that a person might get intimidated and say, what is this technical thing? I'm trying to remove that technical, hyper technical, rocket science concept that is being sold and make it nice and simple. So this discussion, we'll keep it for another time. We can, anytime, we can do it after this recording stops. We can do it, take it after that. But this is our discussion. This is for us to understand. But for a person whom I'm targeting and through this lecture series is a person outside the fold who's not so involved at this current situation in terms of his practice. That's the way I'm looking at it. So we can take it up. We'll take it up discussion. Anything specific that you want to maybe ask her a comment on this aspect, like I told you, who the target audience is. In that sense, do you want to make a comment or a question there?
No. Just wanted
Anything
to
simple, your observation in terms of people coming to the fold? How do we get people into the fold? How do we maybe popularize mediation? How do we identify those with the mediator mindset? These are the relevant questions for me at this stage. So is there anything on that you want to tell me about your experience coming into the profession? What really inspired you? But this is what we're looking at, inspiring people.
All right. You see, like what I said, I have been in the banking industry for more than 30 years. And I was sort of like, headhunted because of my knowledge in banking operations and, and to resolve financial disputes with customers of the bank. So I felt that, with my, experience and all, I'll fit in well and listening. And I like this part of listening to the customers, listening to the complaints, think out of the box and see how best we can resolve the dispute. So that is what I practice. Think out of the box and help to see how best they can resolve the dispute. Maybe not in monetary terms. Customers will demand, oh, give me so much money. Maybe the bank is not empowered, the personnel is not empowered. So we think out of the box, okay, instead of that, what could you do to improve your relationship with your customer? And many a times they have walked out very happy.
These are the kind of things that people have to listen to. This is what I want them to listen to. How you came into the profession, what you thought, what your mindset is, because that is what I'm trying to say, that there is a certain mediator mindset. And there are people out there with that mindset, but they are not part of the profession. First of all, the profession is not developing the way it should develop. The court system is finishing off the profession as much as they can. So they have to, okay, Guna, don't lose that's my view. So that part of it we have to put across and get these people with the mediator mindset in. So if you can inspire people, please inspire as many people to take it up, but then we also have to at the same time create opportunities for them. So that balancing is what I'm trying to do whatever I can do by maybe that militant approach I have to the court system getting into the mediation. So we'll keep discussing this. So anything else in terms of inspiring people, then let's open that out. But otherwise, I think on the technical part of it, we'll have a discussion later.
Thank you very much. Thank you.
All right. Thanks a lot. So Guna, so we can at this point, maybe any final words?
No, thank you very much.
Thank you, Guna. Thanks a lot. And I'm looking forward to that. I'm sure everyone's looking forward to your next lecture. So